and Network Development with World Law Group. Everyone, with the exception of our panelists, will be muted for the duration of the presentation. And we ask that if you have questions that you use the Q&A feature at the bottom of your screen. If you happen to have the same question as another attendee, please go ahead and just upvote that outstanding question. We will try to address questions as they present themselves, but if not, we will get to them at the end. And if we don't get to all questions, we'll address them in a recap of the presentation. If you are experiencing any technical difficulties, you can note your problem in the chat area and we will try our best to assist you. At the end of the presentation, there will be an option to complete a quick survey, and we ask that you please take a moment to complete that. With that, I will now hand it over to our co-moderators, the co-chair of our Restructuring and Insolvency Group, Jonathan Young, and the co-chair of our International Corporate Transactions Group, Victor Turkevans.
Hannah, thank you very much. Dear all, good morning, good afternoon, good evening, probably good night as well. So thanks for attending this session. As you know, Hannah already introduced us. I am Victor Turkevans, also co-head of the corporate department and M&A department of Cuatro Casas, the Spanish law firm. Today, now talking as a let's say, co-head of the International Corporate Transaction Group, let me say the reason why we thought that it could be interesting to put together this session. As some of you may already know, we do not organize joint panels, but in the current situation and in light of the, let's say, the COVID-19 situation, the financial crisis, etc., we thought that it could be interesting to put together this panel with our dear friends and colleagues from the Restructuring and Insolvency Resolution Group, because unfortunately, we tend to think that let's say, the distress M&A might be a hot topic in the near future. So, although it's not a new topic, it might be, let's say, quite a trendy topic in the coming months. As Hannah said, today the co-moderator will be Jonathan Young. He is also co-chair of the Lord Bankruptcy Restructuring and Insolvency Group. He's based in Boston, in the US. He will be acting as moderator, co-moderator, but as well as speaker, because he will be addressing the US aspects of the topics that we will be addressing today. In addition, the other great speakers that we have today are Sadwinder Singh from Bashas Associates Advocates in India. He is the head of corporate practice at the New Delhi office. He is registered insolvency professional and certified associate of the Indian Institute of Bankers. We had the opportunity to discuss quite in depth several issues that we will be addressing today, and he does know quite a bit. Another speaking will be Daniel Kamke from CMS Germany. He specializes in corporate financial restructuring, and he obviously is an expert in this particular field. And last but not least, Vicente Lines from Arias Law in Costa Rica, in Central America. He has wide experience in this kind of restructuring and complex transactions. Let me mention one thing before we begin, is that when organizing the session and preparing the different topics that we wanted to address, I took the liberty of asking my fellow, let's say, colleagues and panelists to try to be, or to try to take into account that many of the attendees might not be experts in bankruptcy law, and therefore, as I did for myself, I asked them to try to keep at reasonable level. Considering that the vast majority of us, again, as I was saying, are corporate M&A guys, and therefore, we would like to have or to be able to follow the general picture. Having said that, again, as Hannah said, you may want to ask questions during the session, but as the Zoom format is not that friendly when it comes to interruptions, etc., probably makes sense to ask the questions at the end of the session, and we will be leaving some room for that. So without any further delay, I give the floor to Jonathan. He will be setting the framework of today's session, and we will proceed from there. Jonathan.
Victor, thanks so much, and good day, everyone. Thank you for joining. One of the things we've noticed over the past couple of months is that our clients are starting to do deals again, and in particular, many of our clients are looking for opportunities in the distressed space, both as asset transactions and in some instances as equity deals. And whenever a client is aiming at a distressed target, there's always an immediate question of structure. Do we want to buy this out of court? Do we want to buy it in court? And in the US, at least, the range of options is as follows. You can simply do a deal with the distressed company, which is probably the quickest and surest path. But if the company is insolvent, you may be taking on some degree of litigation risk, as well as exposure to legacy liabilities. You can do what we call a UCC sale, Uniform Commercial Code sale, by a secured creditor. And that provides a little extra protection in terms of extinguishing junior liens. Or you can do a court sale, a court-sponsored and approved sale, either through a receivership or through a bankruptcy proceeding. And that's really the gold standard in terms of certainty and protection, but it also is more expensive, more likely to produce a competitive auction, and therefore a much less certain proposition. So there is, at least at the beginning, a question which of these paths to take, and we'll cover some of those issues today. Satwinder, I wonder if I might ask you to talk about how those different strategic options look in India.
Yeah, thank you, Jonathan, for giving this opportunity, and thank you for setting that tone. I think you very well pointed out the concept of going for acquisition outside the court or through the court process and the bankruptcy, and that's the important point. I think I thought, just taking a clue from what you have started with, let me just point it out at the first stage. Under the Indian law, unlike in US, where there are even in the court proceedings, there is a concept of a debtor in possession continues. But here, as soon as that petition is admitted under the new Insolvency and Bankruptcy Code 2016, you can take it as a short form as the IBC code, the control immediately shifts from the debtor in possession to the creditors in control, and that's where there's a marked difference. And accordingly, I would say the strategies also gets changed for this thing. So if I put all those techniques and strategies for that acquisitions in India for the distressed assets, I think I can put it into 3-4 different buckets. The first is where we are talking about the acquisition of assets through the court process, where the target is already undergoing the insolvency proceedings under that IBC for that. That's the one category which I would like to emphasize on this. Second category where we are talking about is that where you think about the acquisition outside the IBC process, outside the court for this thing, where the regulator, the Reserve Bank of India, has also come out with the circular, which normally giving the stretch assets framework, and we normally call it as a June 7 circular, also talk about the parameters and the framework for that acquisition, or the resolution for the uh, distressed companies who are sick companies, or and then there could be the other ways outs, like under the Companies Act there is a scheme of compromise under section 230 of the Companies Act and all. And the last but not the least, one can also explore where the secured lenders are taking over the assets which are charged to them under the SARFAESI, and the sale through that auction process. Now, if you see this, if I briefly touch upon all those four aspects, that one is the through that IBC. Let me just give you the there are three prime objectives of that IBC. That was the code which was there. One was the resolution. That the first in priority also, the objective is that there should be a resolution of the corporate debtor. As a going concern, you can continue, and there should be a resolution, and the liquidation is the last resort for this thing. The second objective, which is very important, is the maximization of the value of the assets. And the third objective is where you are talking about the balancing the interest of all the stakeholders. I think those are the three issues which were there for this thing. So the acquisition strategies differ from the different purposes. Like under that IBC, the resolution applicant will come as a white knight person who will send the proposal, who will bid for it. He will give the resolution plan, make it whatever the debts are there. So he may ask for a haircut and all. So he will give the plan. Out of that planned amount, whatever the amount has been given, that will be distributed under that mechanism which is given under the IBC. That's a waterfall mechanism. And once that is there, so the plan invariably asks for the extinguishment of all other liabilities and settling all the other liabilities. So in a way, the jurisprudence which has been evolved over a period is like a clean slate theory. The moment you have acquired, unlike you see in the normal acquisitions, you ask for representations and warranties, and then you seek all sort of other indemnities. But here, once you have acquired it, the statutorily you are, you see, leaving all that legacy liabilities and the baggage of liabilities, and you are coming out with a clean slate. That's the jurisprudence which has been developed so far, and that's the important key of taking the acquisition through that resolution. And particularly when law has recently been amended, even for the non-compliances and the offenses done in the past, I think that they have also given a waiver that the new promoter and the corporate debtor will not be subject to any liabilities for this thing. And particularly under this process, the wisdom of the committee of creditors, which consists of the financial creditors only, is the supreme. I think that's the end and intent. And under that IBC, again, if you are not able to get the plan approved within a time frame which has been given, or the plan is not as per the provisions of the law, and the COC feels that it is a fit case for a liquidation, then they will recommend the liquidation of the corporate debtor. Now, in that liquidation also, again, the concept is that, okay, the company should, so they have brought in the concept of a corporate debtor, sale of the corporate debtor as a going concern, or sale of the business as a going concern, not to stop. So the business should continue because there are other stakeholders like employees, their livelihood is there. Government is also looking for revival of the businesses, so that maybe that today they are relegated themselves at below the mark in the waterfall mechanism, but still they feel that, okay, once the company will revive, the government will also get benefits. So all that part is through that part. Then other than that IBC, outside the IBC, if you are looking at it, is then probably you are talking about the private arrangements where the lenders, the scheduled banks, can talk about through the RBI circular, and they can have a private talks to the investors, and you can acquire, and the secured lenders can give their consents, which is 75% of the value and the 60% in numbers that can come. So if they give a consent, the creditors can also put it. So there is a stressed assets framework that has been given. Other than this is that there is a scheme of compromise. You can put it under section 230 of the Companies Act. And maybe that you can also use as a combo of section 230 of the Companies Act vis-a-vis that RBA framework, and you can draw it as a scheme. And it's open-ended. There are no limitations to that aspect. Right now, earlier there was certain conditionalities, but the way now that circular has been made, so that there could not be any position to that part. Last but not the least, when we are talking about is the acquisitions by the secured lenders through that auction process, where the lenders through SARFAESI can put some assets, but it is largely on the piecemeal sale of assets, not on the going concern, because they will sell only whatever they have been charged to, but there is no resolution mechanism coming under SARFAESI. So I think that's the important part which I'm just making it is that one has to think through it while going, whether I should go under the IBC process or I should go out of that IBC process, what modalities we can see, how we can approach the lenders and see, and accordingly then we can make a documentation to that part. That's the important aspect.
Winder, perfect. Thank you. No, very interesting. And related to that, and when designing, let's say, the possible alternative in order to either take over a company that is in an insolvency situation or part of their assets, one of the things that we have to take into account is how the secured creditors are treated, their ability to actually beat in their debt, and the deep financing, how the fresh money, that's what I learned. Actually, as you know, I'm more a corporate regular M&A guy, but we have been involved in a number of similar transactions lately, particularly. And so, Vicente, can you give us a bit of light when it comes to those issues in Costa Rica?
I will certainly do my best. Like you, I'm also mainly an M&A lawyer, although I have to thank Jonathan for the chance to be in the panel. But in fact, my first approach was also looking, a couple of decades back, looking at a large transaction where an auto retailer was fresh out of its corporate reorganization, and we were looking. Our first look at this was we were really worried about, again, legacy contingencies, like Jonathan was saying, that might come out of one of these processes. In actually looking at that transaction, it really caught my imagination and my attention, because the target had actually done a good job out of coming out, restructuring with a large number of creditors, which were actually bond creditors, which is not that common in a relatively small market like Costa Rica for a corporate concern. And one of the very interesting things is that they had managed to get all those creditors to convert into a small portion of equity, and really pulled off a very long process, about a process that lasted about 8 years in actually reorganizing. And deep financing, or debtor in possession financing, to actually look at your question, is really about two very simple concepts. Debtor in possession, again, the whole principle of debtor in possession, like Sadwinter was saying before, and like I think most of the people who are listening to us today will know, debtor in possession is actually the main principle of a reorganization, and most bankruptcy and insolvency laws throughout the world are really looking at the concept that business continuation is one of the main purposes of insolvency law. So we want the debtors really to be able to remain in possession and management of their companies to the extent it is feasible that they will actually come out on the other end, because that will have positive effects on everyone, including the creditors that are trying to collect. And, that is a long-standing principle of insolvency law in the States, in the US. It was really condensed and codified back in the 70s. And after that, a lot of Western and global frameworks started to do the same thing. So, that second chance really, and in this case that I was mentioning before, was possible because the debtor, the debtor in distress was able also to access financing in this, at the moment where they have started insolvency. So again, in the spirit of making it simple, something, even though it's very, 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 let's say, intuitive to think that, yeah, we do want businesses to be able to continue to the extent that there is no wrongdoing, that it is feasible. We want them to be to be able to continue. It is not that counterintuitive to be, to think, even though we all know that it happens in real life, it's a bit counterintuitive to think that a bank would come in and lend to someone who has already acknowledged, to a business that has already being acknowledged as being in distress. So that is the tenet of deep financing, is that a debtor in distress that is already in an insolvency is able to access fresh financial resources. Now, here comes the interesting part, which is, what does the law, what incentives do these different legislations give? And there, Costa Rica is, let's say, a little bit behind, but catching up. We are following a trend that in the rest of Latin America is probably almost 20 or 20 something years old, which is to reform their laws. And Costa Rica, like many places, and one could argue even the US in the 20th century, our insolvency laws were, spread out over procedural laws, over civil laws, over commercial laws. So there is a movement to amend those laws and make them easier, make them palatable. Again, thinking about insolvency, not in the sense of liquidation, but also in continuation. So we are, in Costa Rica, we are amending our laws following what is happening in the rest of LATAM. No, the question is, do we have the same safe harbors, and what are the safe harbors of debtor in possession financing? Well, the essential one is obviously the granting of priming or super priority rights. And what does that mean? Again, I want to honor Victor's guideline. We're gonna keep it simple, right? We're not gonna throw out a lot of terms of art, but priming and super priority basically is granting the lender that is taking the additional risk, granting them a super priority and the ability to collect before common creditors or senior creditors of the bankruptcy. It's the lender that is making those loans is basically going to be benefited by being paid off first. In the US, that super priority is even above the common costs of the reorganization procedure. In the rest of LATAM, in Costa Rica, we're not even close to being there. I mean, the possibility of extraordinary business transactions in the context of our current laws is merely acknowledged as a theoretical possibility. So anyone actually giving a loan is actually going to be part of the pari passu rights of all of the common creditors of the bankruptcy or insolvency. In the rest of LATAM and in the rest of the civilized world, well, there are incentives in the law, and deep financing transactions and credit rights are recognized to have priority, at least on par with the expenses of the reorganization. And that is a very, very big difference. It's not as, let's say, incentivized as it is in the US, where it's above even those expenses, but still having that priority does allow people to take on the risk as lenders and actually lend in reorganizations. And again, that's key. I mean, if the company is already in trouble, you're going to have to be able to augment their capacity and their financial resources and allow their working capital to actually, sustain them in this new phase. So that's that's basically deep financing, the first layer in a very, very tight nutshell. But I would add something else that I've seen that's happening in most of LATAM. There's a second wave of reforms that countries like Uruguay, like Mexico, have undertaken since 2008. I think was Uruguay's amendment. Mexico, I think, passed their Uniform Insolvency Act back in 2000, and in 2014 they were able to amend it and even to improve deep financing. And for example, I want to take Mexico's example because I think that's something that we want to follow in Costa Rica, which is, they not only grant super priority, but they also establish, I think it happens in the States, the judges, the bankruptcy judges' power to approve deep financing as part of the initial order or insolvency order. And even though our reforms are in small Costa Rica are slated to recognize the super priority rights, we do not have as a specific moment in the bankruptcy, which is very early on, which again, I think favors the whole M&A possibility of scenarios, because again, you need, in these situations, you need fast action, you need quick action. But not only does it expressly empower the judges, it also allows for at that time a black line rule. So it establishes, let's not call it a black line rule, let's call it black line guidance. It establishes, like in the States, that deep financing will be expressly authorized if the requesting party can show that financing is necessary to continue the ordinary course of business and that it is urgent. So again, I think giving comfort to the judges and to the actors in insolvency processes will actually allow these sort of concepts to actually fall into place and to be implemented. And that is something that at least it's a trend in LATAM, and that is something that we hope that in Costa Rica we're able to attain. There are other issues that we can address, but I think that we can address them in the course of more conversation. One of the main ones is credit bidding, which I know that is allowed in the States and in the rest of LATAM. I don't think that is something that has been approved. And just again, so that I don't keep it, I don't throw out too many terms of art. Credit bidding actually, what that actually means is that you are allowed as one of the creditors to use or to set off the debt that you have against the debtor in distress in the case that you actually get to a liquidation. So I think that is also an incentive, and that creates a market for it. And I think deep financing is something that we hope will develop, and we hope that we'll have more market breadth again all over LATAM, and hopefully in relatively modest jurisdictions like ours.
Thank you, Vicente. We do have in Spain, for instance, the credit bidding. And also one thing that we will tackle later is how this deep financing may fit within the prepackaged, let's say, scheme. But Jonathan, can you give us some light in the US, whether it's more or less the same as in Costa Rica?
Certainly, Victor. And I think Vicente really hit all the key concepts. I would say in the States, it's a very well-developed concept. It's really been an active market for this kind of financing for decades. And I think what's happened in recent years is it's really become a strategic tool for the incumbent lender. So if you've got a distressed company and it files a Chapter 11, and of course there needs to be debtor in possession financing to keep the case going and get through a sale process, it can be very advantageous for the existing first lien lenders to provide that facility, because usually the way it'll be structured is what we call a roll-up. let's say there's $100 million of existing first lien debt on the company. Those lenders will loan $140 million under their DIP. They will pay off their existing facility and roll it up into this new, as Vicente described it, top of the capital structure credit. There'll be $40 million in new money to cover the expenses of the case. And then when it comes time to sell the operating assets and potentially to have some competitive bidding, you've now substantially increased the amount a competitive bidder has to pay to come in and have a chance to compete for the assets. And therefore, we've actually started to see a fair amount of, in some instances, reluctance to accept a debtor in possession financing from the incumbents, precisely because it can chill the sale process. So, for example, we were involved in the Brooks Brothers case in the States on behalf of one of the lender groups, and we saw that Brooks Brothers quite consciously decided to take their DIP financing from a lender that was not a part of that credit facility, precisely because they felt it could let them run a more competitive sale process. So what I would say, Victor, is that it's a very well-developed process. It absolutely puts the lender to the top of the capital stack, and if it's an incumbent lender, potentially enhances their credit bidding rights. And for an outside lender, there's also a fair amount of premium charged on the pricing. Daniel, I wonder if I might quickly ask you if Germany recognizes similar concepts.
Well, there are some quite similar concepts. Well, you must say that in Germany we are quite on our road to have a new restructuring law coming up at 1st of January, where we have some quite very similar concept in there. A little bit of reforming our law for the out-of-court restructuring there, but this is absolutely the case. And at the moment, we have, let's say, concepts in the out-of-court restructuring, which is more or less depending on what is the contractual situation between the parties. And on the other hand, you have our in-court restructuring situation, where of course you have all these regulations in place, like all the collateral agreements and something like this. But on the other hand, you are quite free to restructure all the whole situation. I would say you can restructure it from the corporate side, you can restructure it from the financial structures. This is everything is possible in these in-court restructuring situations where you can act with a pre-packed plan and something like this.
Thank you. Satwinder, does India recognize the concept?
Jonathan, I think on that, I think as you said that, okay, the concept is well developed in US, and Vicente also talked about the definancing issue. I think again, when I started with my opening aspect for this thing, what is that in court proceedings and out of the court resolutions for that. So let me say that, okay, this concept as such, though it's not that well developed, but it is there where it is the out of court resolutions when the debtor in possession is there already for this thing. So there are lenders who cede charge to the, we normally call it as a mezzanine financing or last mile funding, you can say, to complete the project and let the company continue and the existing lenders cede their charge. That concept is available. And I'll just give you the example, even the COVID, there's a fund which is called a Swami Fund, launched by the Government of India to help the real estate sector in India and they're funding the real estate companies to complete their projects, and the existing lenders are ceding their charge on that part. I could see, even I'm handling one matter on this thing where the existing lenders somehow they raise their hands that they'll not be able to fund more, and a new fund has come in and taken that the super priority charge, and the existing lenders are, they have agreed to the subservient charge by agreeing to a certain portion of the area which is to be developed, and which they are making it is. There are number of asset reconstruction companies, probably they are buying the debt, you see, assigning in their favor, then they're approaching the capital market for raising funds to complete the projects. So as such, the concept is there. But if it is, you see, in court proceedings for this thing, probably that is not worked, but the law provides for the interim finance. And the moment the resolution professional can talk about the interim financing, then you see it will be a super priority, because it will be treated as an insolvency resolution process cost, and that has to be paid above everything all. And then it depends upon, though the concept as such has not been developed, but yes, out of court there is a concept which is there. In court, the provisions are there for raising the interim finance. That's what I'm just making it is.
Thank you.
Thank you very much. One of the other issues that we wanted to address today, and again, thinking as a more regular M&A lawyer, is the actual sale process, and how it could be implemented, and when, let's say, the company has to take, control of its own sale or part of their assets, and when this process has to be supervised or overseen by a trustee or receiver, etc. So this is always a risky discussion, because companies tend to be inclined to do it themselves, but they may get into problems if they do not succeed. So I wonder how you address these issues, Daniel, in Germany.
Yeah, Victor, I think quite a broad field. Will try to do my best to give you a brief overview. Well, first of all, I think you have to distinguish between an in-court and an out-of-court restructuring situation. Well, first of all, the out-of-court situation. This is a situation where you have the debtor, its shareholders, or management, in general, free to sell the company or parts of the business. Well, however, there are situations where creditors, especially banks, insist on implementing a trustee. In these cases, the trustee takes over the shares of the company, prepares the company for the sale, and runs the M&A process. And at the end, this trustee will pay out the proceeds from the purchase price according to a waterfall regulation, which is in most of the cases determined in advance or follows out of the existing contracts. Well, in this out-of-court restructuring, you also have a problem that there is always a risk of a bankruptcy of the selling entity, leading to certain clawback risks. This is always a problem in this out-of-court situation when you sell out of a company in a financial crisis. And if this happens, there is a risk that later an insolvency administrator is contesting the sale and claiming back the sold parts of the business. On the other hand, you as a buyer have only a claim to receive the purchase price back as an insolvency claim, which means you will just get a quota on your claim. This risk in Germany can last until 10 years after the M&A process in the worst case. In general, you can say that this risk is much higher the sooner the bankruptcy kicks in after the sale. So therefore, we have much more M&A processes out of an in-court situation. Well, maybe a last point on the out-of-court situation. You ask for the decision to sell, well, whether the entire business or parts of it. It is a little bit a question of an economical question or a strategical question, I would say. There are no legal requirements on that. Well, I said maybe a little bit more important in-court situation is in an in-court situation, you have also to distinguish between a straightforward insolvency and a debtor in possession proceeding. In a straightforward insolvency, it is quite simple. You have an insolvency administrator in place. He takes over the control and will also run the M&A process. In this debtor in possession proceedings, the management of the respective company will run the process, but it will be supervised by a trustee, which is normally nominated by the insolvency court. So the task of this trustee is just to make sure that the management acts in compliance with the insolvency laws. This is what is really his task under the law. However, you have a certain situation where he really tries to get some more influence on the M&A process too, but normally he's just a supervisor. Well, any case, even if, or in any case, you have the straightforward insolvency or the debtor in possession proceedings, the final decision about a sale is made by either the creditors meeting or creditors committee. Well, the creditors committee will decide if the creditors meeting has decided to appoint a creditors committee. In an in-court restructuring, you also have the legal requirement to achieve the best possible outcome for the creditors, which means you have to just satisfy the creditors as best as you can. So you have to assess whether it is preferable to sell the entire business or just parts of it. And this primacy also applies to the question whether you continue the business of an insolvency company to sell, let's say, a living business or a living company, or you send the people home, close the business, and just sell the assets. In most of this situation, these companies create losses. And to continue the business will create more losses. But most of the situations show also that the prospects to achieve a good purchase price are much higher if you sell a living business. Therefore, in most of the situations, the insolvency administrator decides to continue the business and to sell it as a living business, which is at least, and this is maybe some remark you might have, this discounts for, let's say, mid and large cap cases. The smaller insolvency cases, of course, are very different, but I think we are really talking about more these mid cap and large cap situations here.
Okay, thank you. Thank you very much. Related to this, Vicente, for instance, how does this work in Costa Rica? I mean, the unauthorized trading operations, I mean, the obligation to stop or to stop doing business on regular basis. I mean, there is an obligation, there is a clear cut when you do need to stop. Vicente, I'm sorry. I cannot hear you.
Okay. Now you can hear me.
Yeah.
So the general principle is, again, as I said before, that the debtor should remain in possession. Under our existing, this is under our reform, under our proposed reform, which is, I think, the case in most of the LATAM jurisdictions have already amended and unified their insolvency laws. So the general principle is that debtor remains in possession. And what that usually means, Victor, is that the debtor will be able to do anything that is within the confines of the ordinary course of business. The problem here is, I mean, what we're really thinking about is we're thinking about extraordinary transactions. We're really thinking about, we're hopefully setting up it up in the context of an M&A, an acquisition of the key asset, an acquisition of a division, or the whole ongoing business. there is, I mean, even in our proposed reform, there are major limitations. I mean, you generally cannot sell off a key asset or a major asset or any asset outside of the ordinary course of business without authorization from the judge. So I think that, you know, keeping it short, I mean, in general, all of these transactions would be generally set aside. And I think, you know, that presents interesting issues when you're actually thinking about dealing in a major M&A transaction. And I think that is something to really watch out for. And hopefully you are able to identify in the different legislations, you know, small safe harbors where you can actually be dealing with. And I think this segues well into the next topic I think that you have.
Okay, Sadwinder, what about in India? More or less the same?
I think that's what Daniel was also saying and Vicente was also saying for this thing is as regard the in-court proceedings are concerned, the moment that has been admitted, the existing board of directors, the board gets suspended and the powers gets vested with the resolution professional. And he's charged with the responsibility to continue and carry on the operation till the time that resolution has been taken place. And even you see under liquidation, the liquidator is asked to continue that operations for beneficial liquidation. So basically, the concept of the going concern continue even in India for that part. And even if it is outside the code, when there is a debtor in possession continues, and where there is a resolution by the creditors pose many conditions. Sometimes the change of management, the change of board, they will be into the minority, some majority shareholder will come. That is the position where you are talking about. But I think, Victor, the important part, I think you have raised one very important issue, which is coming up to my mind, just occurred to me now, is the fiduciary responsibility and the fiduciary issue which will arise for that resolution professional to continue. Maybe whether I have all that bandwidth to continue that operations, I have that expertise to continue that operations, that arises for that. And somehow, which the other day I was discussing with Jonathan, that how the trust litigations on those administrators and receivers, when they are continuing, that arises to that part where probably that is into a nascent stage where I don't think that here the resolution professionals are even seeking the insurance cover and all that. They are operating it. You don't know. Today you're talking about the fair value and the liquidation value. You never know whether that value will continue to be maintained by that resolution professional. Those issues may come, but yes, the right now the legal position is where we are talking about they are mandatorily required to take charge of that assets to run it. And even in that liquidation, which I was just saying is, even if it is liquidation, the first priority for the liquidator is to explore the possibility of sale of the corporate debtor as a going concern, or if you are not able to, then the sale of the business. And if that is not happening within a certain threshold limit for this thing, that a time period, then you explore the piecemeal sale of assets. So the sale of assets or a combination of assets. So that will come. But so long the process is not over, they have been assigned the responsibility to continue to run that operations.
Okay. Jonathan, what about in the US, but brief, because we are, as you have seen, we are running late.
So there was a trend in the US about a decade ago that creditors would sue the directors for continuing operations on the theory they were deepening the insolvency of the company. That theory has been rejected. There's no per se rule under US law that you got to liquidate to enhance creditor recoveries. But I think when a company's insolvent, the directors are going to be judged by whether it's reasonable to keep operating on a case-by-case basis. And ultimately, this is really about maximizing value for all creditors and equity holders. So that's kind of the framework on which it's going to be judged in the US, and it's going to be a case-by-case basis.
Okay, that makes sense. One related issue in relation with the transfer of business units or the company itself, how do we address the conditions precedents? Obviously, if this is a small business, let's say, all what you have just said does work with maybe more or less complex. But let's imagine that we are facing an insolvency process in which it's a very relevant company and antitrust clearance might be needed, or the green light from the, I don't know, the European Central Bank in Europe, or the relevant insurance authority, etc. How you deal with these CPs in the framework of these kind of processes? Daniel, any thoughts from a German standpoint?
Yes, indeed, Victor. There are of course souls and of course experience with that in Germany. Well, on the one hand, I think you have some clearance decisions for which you can get binding decisions in advance, which is very good and which simplifies the whole process very much, as you don't need this as a CP for your process. On the other hand, there are more complicated issues, and especially the antitrust issues, and I think this is quite a similar issue for us in Germany. It is quite a new one, but I think in the rest of the world it is well known. I know that is also a big issue in the US, and this is the investment control issue. These issues always cause a delay in the sale process, and these approvals of the respective authorities take a lot of time, and you have to add this as CPs in the agreements, and there is no possibility to file for these approvals prior to the transaction. In distressed situation, this always means that you have to find some agreement between the buyer and the seller on how to deal with the losses the business is creating between signing and the approval, or I would say much more important, the refusal of that approval. In this case, you have to find someone who's taken over the losses, because especially in an in-court restructuring situation, an insolvency administrator would have quite a big problem to take over the risk, taking over all these losses in case that a filing with the authorities is not successful. Another question that really comes more often in restructuring situation and even in smaller or mid-cap situations is that you have some restructuring measures before you sell anything. This could be haircuts or debt to equity swaps, and these measures in a lot of cases cause a taxable profit, and therefore and you see this in most of the cases is only book value, which means the company has a profit but has no money, no liquidity to pay these taxes. In most of these cases, the financial authorities waive such taxes to enable you to have a successful restructuring and to keep all the employees and something like this. So this is in these cases the financial authorities in Germany are very supportive, and this is also something positive. You have the chance to file for upfront binding decision, so you can start your M&A process with having this binding decision, and you have the certainty that this will not cause any taxes in Germany. So both is possible. Sometimes you have these CP situation where you have to really look after who's taking over the losses that will be created between signing and closing, and on the other hand, you have the situation where you have really certainty in advance, which is of course much preferable.
Okay, and one thing that we are not talking about, but it's also a hot topic and might have an impact in this kind of transactions, is the foreign direct the FDI screening nowadays, which also could have an impact in this kind of transactions. Jonathan, any comments from the US standpoint? Again, sorry for insisting. We all should try to be brief now.
Yeah, I just think it's really transaction by transaction, case by case. I think there's got to be a lot of strategy and thought given to, how the conditions and the timing are structured. And I can't say there's a general rule in the US.
Okay. I don't know whether, Sadwinder, do you want to say a few words? I wanted to talk, no, Jonathan, I think that you wanted to talk also about the prepackaged plan.
Yeah, I'll cover that briefly. There's an ability under US law and practice to solicit support for a transaction before filing the bankruptcy or insolvency proceeding. And assuming that your solicitation was good and your notice was good, you can have the court act very quickly after the filing of the case. And in fact, there have been a couple of one-day bankruptcy cases in the States where solicitation occurred over a 60-day period. All the consents were lined up. It was a balance sheet restructuring that didn't impair the trade debt, and the case was filed and the plan was confirmed the same day. That's an extreme example, but I think U.S. practice very much favors prepackaged, if not even solicitation, prepackaged development of the restructuring terms, and the idea being you negotiate the difficult issues beforehand. And that reduces expense, it reduces uncertainty, and it avoids the stress on the business of a lengthy stay in bankruptcy court. So I think it's a great tool in the US, and it's definitely something in the right case we all take advantage of.
Understood. And is it regulated in the law, or is a general practice from the court? For instance, in Spain, we do have a similar thing, but it's more, let's say, developed by the courts, but it's not properly regulated in a relevant piece of legislation. And therefore, it's always a kind of a risky situation.
Well, I think in the States, you're going to do it in a process that culminates with a court order. And as part of that order, the judge will find that notice was sufficient, that the rules were followed. I mean, I think the beauty of these prepackaged arrangements is they fit within the statute. You're still going to solicit votes. You're still going to show that all the elements of the statute were satisfied. You're just going to do it very quickly. So I think that if you're doing an in-court prepack, you can feel pretty comfortable with it because the judge is going to sign off on it.
Understood. Vicente, any comments from your end?
Certainly. I mean, prepacks are also a trend in a lot of the legislations that I mentioned. And again, they're being adopted in Costa Rica too, but they already exist. Again, Mexico, Uruguay, Peru. And I think prepacks, like Jonathan said, I mean, the beauty is, it's not about, cramp down rights or, imposing decisions on certain classes of creditors. It's the same rules of approval, the same consents, but it's just done quickly. And the fact that it is foreseen in the procedure, something that can occur prior to the opening of the insolvency, I think makes it very attractive. In Costa Rica, they are, in the proposed reform, they are being, let's say, positive and thinking that, and you know, and saying that once a prepack is posited to the court, it will give notice to all of the creditors and try to have everyone's opinion in 2 weeks. So again, it's really a function, like Jonathan was saying in his example, you know, it's really a function of you being able to undertake the effort to actually prepare those agreements and actually get everyone on board. But the fact that you have a statutory track and that the judge is going to be obligated to look at it, and that you're not going to be stuck in a, you know, let's say an uncertainty circle where the judge is, you know, where someone is saying, okay, no, you have to open the insolvency process beforehand, and it's actually foreseen in the law that the judge has to make a ruling on it, I think makes it very attractive. Sorry if I went over, but I think it's one of the more interesting things.
No, we wanted to touch also the valuation issue, but as we are running late, Jonathan, what do you think? Shall we proceed with the valuation or rather go for the questions that we have gotten so far?
I think we should go to the questions, Victor.
Yeah, I would agree, because otherwise we would skip the questions and probably the audience are more interested.
Victor,
yeah. Sure.
Victor, just before I'll just see the Daniel issue on this thing, the Daniel, which he talked about the tax aspects. When we're talking, I think it's very, very relevant even from that Indian standpoint of view, where you have to really analyze it, that what could be the tax impact when you are really seeing that haircuts, and it will become an income in the hands of the corporate debtor, whether it would be taxable or not. And the other aspect is the stamp duty issues that you really need to see to it. And particularly even on that pre-packs, probably in India, those are, you see, it's a nascent stage. The discussions are going on for the in courts, and there are two schools of thoughts bringing, because here the objective is the maximization of value of the assets. And why not that open bidding process? So the two thoughts are going on. It's not codified here, but I thought that let me just supplement that for that.
Edwin, perfect. Thank you very much. So, Jonathan, do you want to take the lead in asking the questions?
Yeah, I want to quickly cover a question that was raised from the audience to Daniel. I'll read it. Daniel, you mentioned that there are very little special legal requirements for out-of-court restructuring situations and a respective distressed M&A process in Germany. Doesn't that create a high level of uncertainty for the parties?
Yeah, well, that's true at the moment in Germany, and that caused a lot of problems during the past. We really must admit that, and we have a situation where the legislator in Germany has reacted on that. So we are expecting a kind of a framework for out-of-court restructuring coming into force on 1st of January 2021, which we are really looking forward to, because we have a lot of case law on that, but this is still developing case law, which of course creates more and more uncertainty, because you never know what you really can rely on at the moment. So it is always, or has always been, a kind of a risky situation when you go into out-of-court restructuring situations here in Germany. But we hope that this new law we will have for out-of-court restructurings will solve this problem, and we have I think, and it looks like a really good framework we will have from 1st of January.
Thank you. We've got another question. I'll read it. In a court-approved equity sale transaction, does your jurisdiction recognize the court's power to drag along minority equity holders not a party to the insolvency proceeding? I'll say in the US, the answer is it depends. I mean, your question is well asked, because you're asking, you're assuming that they're not a party, and that might create jurisdictional issues and notice issues. I think in the States, you know, certainly to do a drag along in conjunction with a court-sponsored sale, you would need to give notice, and you would need to make the minority equity holder a party to the request. Whether it's approved or not, I think it's really case by case and depends on probably the language of the underlying agreement, as well as, whether the the minority equity holder has done things contractually to submit itself to the drag. I don't know if any of the other panelists want to speak to that one.
Or maybe can answer that from a German side. And in a German side, you have to treat all stakeholders of one group, and it is in this case we would talk about the group of the equity, so the shareholders equal. Therefore, you would have an automatical inclusion of these minority shareholders into that. So therefore, you can't have a court-approved equity sale transaction without taking care of the minority.
Okay, thanks very much. Victor, do you want to jump in there? Go ahead.
No, I just wanted to see whether we have time for one additional question, or we are running a bit late, and I see that some of the attendees are leaving. So if there are no more questions, probably we can stop here to the extent that Jonathan or the other panelists do not want to add something.
I just want to thank everyone for joining and suggest we're going to see a lot more of these distressed transactions in coming months. And, they're challenging, but they present some opportunities as well for our clients. So we'll see how it all progresses.
So thank you very much. And I do hope to see each other personally in the near future.
Yeah.
Thank you very much.
Thank you.
Thanks.
Thank you. Thank you.
Bye now.
Thanks, everyone.
Bye.